Good morning. Today we're going to talk about the very delicate subject of food fraud and what that means in South Africa. The term gets bandied around a lot in South Africa, but not everybody understands what it actually means and what the implications are. So, in South Africa, food fraud is not defined as such in our law, but there are certain laws such as the Foodstuffs, Cosmetics and Disinfectants Act and the regulations which make it a criminal offence if for the purposes of sale you describe any foodstuff in a manner which is false or misleading as regards its origin, nature, substance, composition, quality, strength, nutritive value or other properties, or even the time, mode or place of its manufacture. So although the food fraud term is not defined, certain acts are made criminal offences. The Agricultural Product Standards Act, which is another law that deals with certain foodstuffs more of an agricultural origin such as milk and juices and eggs and the like, likewise states that no person shall use any name, word, expression, reference, particulars, indication in any manner, whether verbal, written, printed, illustrated, visual, etc., for the sale of a product in such a manner that you convey or create or are likely to convey or create a false or misleading impression on the nature, substance, quality or other properties, or even the class, grade or origin of goods. And this is very important because often food fraud comes down to misstating the class or the grade, or in some instances the type of foodstuff, of course. We then come to the Consumer Protection Act, which is an umbrella law that protects consumers rather than dealing specifically with foodstuffs. But in the Consumer Protection Act, it is stated that a person must not knowingly apply a trade description which will mislead a consumer as to any matter implied or expressed. So if I'm selling you turmeric, but in fact it contains ground peanut shells, that would clearly fall under this type of definition. Then it goes on to say that a retailer must not offer to supply, display or supply any particular goods if the retailer knows, reasonably could determine, or has reason to suspect that the consumer will be misled. Now this is very important because retailers in South Africa like to play the game where they say, well, we didn't know, we simply buy it from someone and it goes on sale. The reality is that the Consumer Protection Act makes it their responsibility to the extent that they either knew there was something wrong with the product or could reasonably determine that there's something wrong with the product. You may say those are still fairly high hurdles, but at least you would have a reason to suspect in many cases that there's something wrong with the product simply based on the price that it's being offered at or other characteristics of the product. Section 29 of the Consumer Protection Act states that a producer, importer, distributor, retailer or service provider must not market any goods in such a way that it is reasonably likely to imply a false or misleading representation concerning those goods or services. Furthermore, you cannot give misleading information as to the nature, property, advantage or use of the goods, or for that matter of fact, mislead the consumer on any other material aspects. So once again, there's a criminal prohibition on misleading the consumer. Section 41 reinforces what Section 29 had said, and again it puts even a further burden in that it says that even if you've failed to correct an apparent misapprehension on the part of a consumer, that amounts to a false, misleading or deceptive representation. So when people sell a product and they tell you this is Manuka honey, and it's simply normal honey, or worse, it might be some sort of sugar syrup, they would in fact be contravening this section as well. So in South Africa, the main object of the Consumer Protection Act is to protect consumers against exploitation, poor quality, defective, unsafe goods. But the most important part of the Consumer Protection Act is it gives the consumer redress in that the consumer can go and lodge a complaint and then they could get something for doing that. Whereas all these other laws, such as the foodstuffs law, the agricultural laws, The result of a complaint to them, at most, will be a fine or prosecution of the perpetrator. There is no recourse to the consumer. So let's turn now to what is a general definition of fraud. Because we now know, of course, if you mislabel your product, if you claim that your product has specific characteristics and the like, you could fall foul of one of these laws we've spoken about. But in South Africa, there's a very general definition of the term fraud, and it says, fraud is the unlawful and intentional making of a misrepresentation that causes actual prejudice or which is potentially prejudicial to another. It's very important that there's got to be an intentional making. So not all contraventions of the laws I've just discussed would constitute fraud, because they may have been unintentional even though they were illegal. There's another definition of fraud, which is that it's an intentional deception by concealing or misrepresenting information that harms the financial interests of another person and benefits the financial interests of the perpetrator. You can well imagine that if I'm selling a fake product which normally costs 100 Rand a kilo, but I'm now substituting it as something of inferior quality or lower value, this definition would apply. What happens in terms of enforcement in South Africa? Well, if in contravention of the Foodstuffs Act, the prosecution could result in a 6-month or equivalent fine. It can actually go up to 2 years or an equivalent fine if you're caught and prosecuted 3 times. If you ask me, the biggest penalty which you can actually impose on some of these people is forfeiture of their goods. If I have a warehouse full of product which I'm going to forfeit, it's far more than any fine that can be imposed. The Agricultural Product Standards Act, they have a system whereby they can issue search warrants, they can raid businesses, they can raid warehouses, and then they can see if there was compliance with the various product specifications. There is an appeal system in place in case the raid was done incorrectly. If you are prosecuted, the fines are very similar to that under the Foodstuffs Act. Consumer Protection Act, this is the one with the big stick, because once the complaint has progressed through the Consumer Protection Act, the final outcome of it is that it's in fact possible to fine a company up to 10% of its annual turnover, which you can well imagine in the case of one of the very big retailers would be in the billions of rands. Similarly, that would be definitely in the higher hundreds of millions or billions for some of the big food producers or importers in South Africa. So presently, there's very little enforcement in South Africa against perpetrators of food fraud, even though there might be increasing action under the Agricultural Product Standards Act in particular against people who are selling non-compliant products. Not necessarily fraudulent, but the labels are not compliant, the quality is indicated incorrectly and the like. And now finally the National Consumer Commission under the Consumer Protection Act has indicated they'll be taking a stand on food issues as these affect the poorest of the poor. However, the actions to date have been mainly on expired foodstuffs, which once again is not really food fraud, because there is no really such thing as expired foodstuff. A food may be beyond its so-called best before date, but could still be edible and quite safe to eat and the like. So the type of matters which they should be taking on is, for example, a case which I dealt with, which was where diabetic chocolate was being sold with 45% sugar, but they were misapplying their resources by looking at expired foodstuffs. So to conclude, when one looks at food fraud in South Africa, we are looking at examples such as these, which actually are quite minimal. Retailer in KZN selling cream cake which didn't have cream. You had this imitation creamy substance that they use on cakes. They got 2,500 Rand fine. Meat species fraud that was in the paper, I'm sure many of you would have heard of, is there horse in my wors? Well, you'll be surprised to know no one was prosecuted for that entire Indaba. People were selling boerewors with crocodile in it, with any animal that you can think of with any number of legs. No one was prosecuted. And then finally, a failure of the system. There was a sale of pork hearts as halal in South Africa. the company was prosecuted, but they won. Because there was a failure in the prosecution, the procedures weren't properly followed, and accordingly a potential perpetrator got away. Of course, since the court held that they weren't guilty, they're not guilty. Thank you very much. The term gets bandied about a lot in South Africa, but not everybody understands what it actually means and what the implications are. So, in South Africa, food fraud is not defined as such in our law, but there are certain laws such as the Foodstuffs, Cosmetics and Disinfectants Act and the regulations which make it a criminal offence if for the purposes of sale you describe any foodstuff in a manner which is false or misleading as regards its origin, nature, substance, composition, quality, strength, nutritive value or other properties, or even the time, mode or place of its manufacture. So although the food fraud term is not defined, certain acts are made criminal offences.